Motion to enter adjudication of guilt and revoke community supervision, and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney. Did you understand it?
Today's courtroom drama centers on Christian Grant Hagen, whose probation and freedom hang in the balance. The state moves to revoke his deferred adjudication, accusing him of violating probation. But a twist appears: new drug charges with no lab proof. The judge instantly spots it, raising doubts about the state's case. This hearing isn't just about one man's mistake, it's about how fragile second chances really are. Stick around, because this judge's final decision is going to surprise you.
Hello, Mr. Hogan. All right, why is your daughter not with us? I'm used to seeing her now. Is she back in school or studying?
You need to talk to her. She took the LSAT.
Yay.
Giving up to taking a gift. I'll tell you something. I think she did great, but she heard the stars.
No, because do they still do that? I remember they said if you took the LSAT and then you did another one, then they would just average it. You can't just say, they don't do that anymore? Oh, you can take it as many times as you want to?
You can only take it 5 times.
Oh,
I'm not up on the rules, but I know the rules have changed.
I challenge all of us to take the LSAT again. It'll bring back memories. Bad memories, right? All right, so on this case, are we here on a motion to revoke? What are we here for?
We are, Your Honor. We're here on a motion to revoke, and I believe the state filed a motion to amend the motion to revoke, and it was filed on September 29th.
Here's a legal slip-up in real time. Prosecutors add a drug possession charge without lab results, proof that doesn't exist yet. The judge isn't having it. She knows cases live or die by evidence. This moment shows how details decide destinies in court. Defense attorneys love moments like this, when procedure becomes protection. What do you think? Should prosecutors be allowed to file before results come in, or wait until the evidence is solid?
Yes,
All right, just 1 second. Okay, there's nothing attached to this.
He said that the DA's printer hasn't lost ink and it was emailed to them.
I'll accept, I'm fine with service by email, if that's okay with you.
Okay, all right, thank you.
I wrote it on there too, Judge, email to the best guy.
All right, thank you.
We're working on getting the ink restored.
All right, thank you.
Part-time to the county judge.
All right, thank you. And then on Hogan, I don't have the motion to revoke file. Hogan. Oh.
Should be put up there.
Right, all right. And so it's set for today, and what is the issue?
Your Honor, the first amendment was filed yesterday. This is the first chance I've had to get to talk to my client. I was wondering if I could have some time to prepare him and talk to him about this case.
All right, do you have the original motion to revoke? Because I only have the First Amendment. Where's the original?
Would a copy suffice?
Bashad is bringing it.
Oh,
Thank you. We made it. So the only thing that I see that's been added is a possession of a controlled substance.
Yes, Your Honor, that's one of the new number 1.
All right, do y'all have labs for that?
We do not, it just occurred.
Then labs, are y'all expecting to have those labs in 10
No,
minutes?
I told counsel, there's no way we'll get those back anytime soon.
So then the First Amendment really has no bearing, because they're not going to be prepared to proceed on the violation of condition of number 1, possession of a controlled substance. So I don't know why it was added. They don't have any labs for that. They're not going to have labs for that. And it'll probably be 6 months or whatever before they get labs for that. So
Now, the tension rises. Christian's past charge, assault and impeding breath, makes any slip serious. When he pleads true to missing a drug test, the stakes shoot up. That single word gives the judge power to revoke probation and send him to prison for up to 10 years. One missed test could end his second chance. This is the courtroom moment where honesty meets consequence.
really the only thing that's going to be proceeded on is Probably the original.
Original.
Yes.
Can we pull on that right now? Yes.
State.
May I see the,
Yes. And just mention the one thing.
Sure, Your Honor, yeah, just so the court knows, on the original, the other new number one, the evading was dismissed by our office, so literally the only thing left is the number two.
Do I have a file stamp, please? Yes. So is this a case that criminal trial division or is family violence going to handle? Because there's nothing that will be left in here that is criminal trial division. The evading has been dismissed.
Your Honor, my understanding before that was the discussion is that we were going to handle it, but I haven't conferred with family violence since.
All right, if you want to confer maybe with family violence, because it appears that the only thing on this motion is going to be failure to submit.
And we're gonna plead true to it.
Okay. So I don't know who's going to be making the recommendation on their side.
Your Honor, I'll proceed on.
All right, the court is calling 2024 CR 0077778 State versus Christian Grant Holguin. Can I have parties announce?
Melissa Albin for the state.
And Eric DeWalt, I represent Mr. Hogan.
And are you Mr. Holguin?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Christian Grant Holguin who was placed on deferred adjudication in 2024 CR 0077778 for the offense of assault family household member impeding breath or circulation on October 31st, 2024 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
You can proceed on number two, Your Honor. On or about the 15th day of August 2025 in Bear County, Texas, the defendant Christian Grant Holguin did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number two.
How do you plead to that, true or not true?
Christian's lawyer argues this was just one mistake. He's been working, staying clean, and doing well. But the law isn't built on excuses, it's built on conditions. One mistest breaks the deal. It's hard not to sympathize, though. He's trying to turn his life around. What do you think? Should one slip-up erase months of progress? Or should mercy play a part here?
Surely on.
State,
We'll waive the rest, Your Honor.
any objections to the waivers? Did you understand by pleading true to violation of condition number two, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine? No, my question is, do you understand
Yeah,
that?
ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition number two? Court will find violation of condition number two true. Is there a proposed agreement?
My understanding is there is not, Your Honor. The state is recommending that we follow the probation department's recommendation, which is to have the defendant submit to SATIF, withdraw the MTR and alter and amend his conditions for SATIF.
All right, so the MTR can no longer be withdrawn because he's
Oh,
already played.
That's right, Your
So-
Honor. I apologize.
No
But,
problem.
That's what we would recommend, is that he go to SATIF.
All right, so defense, what are you requesting?
Your Honor, exactly that. I just spoke to my client. He was under the understanding that he had a possession of drug paraphernalia when he did complete SATIF and does have a full-time job and understands he's going local to the court. He missed this one drug test because he couldn't get there on time. He has drug tested before and they've all come out negative. This is his first MTR. He seems to be doing very well on the deferred adjudication. He understands he's up in front of you with the full range of punishment and kind of going open to the court. But wanted to address the court and ask that if he could have a less structured modality that he could continue to work.
All right, before you address me, any objection? I haven't opened it yet, but any objection to the court reviewing the court summary? All right.
Next. Or do you?
Oh, yes, they emailed me.
Okay.
I receive it by email, but I don't open it until parties have no objection.
Christian pleads for understanding, blaming homelessness and bad luck. But the judge isn't buying the one-time excuse. One time is enough, she fires back. It's a harsh truth. Probation is a privilege, not a guarantee. The judge reminds him that rules aren't flexible just because life gets messy. This is where justice meets discipline, and emotion meets the law.
All right, probation, what are you recommending?
The recommendation is for residential treatment at status followed by aftercare and continued on the ISD case.
Is it possible to do, just do the aftercare portion, or has the time frame between being in SATA?
Well, he didn't do status the first time, Judge. He did local ISF.
Ah, okay.
So as you know, local ISF is more geared to cognitive, and then the SATA has that substance abuse. I was in the midst of looking up why he did not qualify for a drug court. If you would
Yes,
like to know that.
yes. And then you want to raise your right hand for me?
Yeah.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Christian Grant Hogan.
All right, so it appears there's something you wanted me to
Yeah.
hear. Did you want him to speak to me, counsel?
That's his intention. It's your intention to address the court.
Yeah,
Correct?
no.
Yes.
I just want to let you know, ma'am, I understand this, what they're recommending. I just feel like, and you, it's been fair since I've been in your courtroom, ma'am. I already completed ISF, which, is.
So here's the thing, let's get to the crux of the problem.
Yes,
The
ma'am.
problem is you didn't report for your UA. Why?
One time, ma'am, I was.
No, let's not do the one
Okay,
time,
well,
because
I'm
one
saying
time
what-
is enough. Wait. We have to speak one at a time. And so let me explain something to you. So don't tell me it was only one time. And the reason why I tell you not to tell me that,
Then comes the verdict. The judge offers two paths: 2 years in prison or probation with GPS monitoring. It's tough love, accountability with opportunity. The GPS keeps him employed but under close watch. It's a fair but firm balance, rehabilitation without blind trust. In this courtroom, mercy comes with metal.
is because those are conditions of your probation. One time for anything is enough for you to be revoked and sent to prison. So don't say it was just one time, because that's making excuses, right? Just tell me, why didn't you report?
Well, when I first got out, I'm gonna get to that. I was doing well. I was remodeling homes with my brother, and I was always in contact with my probation officer. And I had just lost my efficiency, man. And so, being in the streets, having my things stolen, lost the storage, and so and these are not excuses, man. These are the truth. I had trouble with cell phone, and I always made sure I emailed when I didn't call her. And so, fast forward to the motion to revoke. I had just over there, I want to say 7 days prior to the motion to revoke, because I hadn't been able to speak to her, and that's the reason why I missed it, because I'm having to deal with wanting to get shelter, and I was living in Fishing, and I went to the hotel, and it was just hard, man, and that's just all I can tell you.
Here's the thing, I'm going to give you a choice. These are your choices. There's no other choice, right? Here's your choice. I can revoke you and I will sentence you to 2 years in the prison. That's one choice. Or either your second choice, I will continue you on probation. And what I'm going to do is it's going to be an intensive supervision. And I'm going to start you off with GPS. And that will be partial GPS for employment only. Those are your two choices. There are no other choices. Do you need to discuss that with your attorney?
No, ma'am. Could you please waive the fees on the GPS?
Yes.
Yes, ma'am. I can do it. I can do it, ma'am.
All right, Ms. Abrams,
Thanks.
I'm going to deny the motion, alter and amend conditions, to include partial GPS for employment only, waive fees, and intensive supervision with probation and intensive outpatient treatment with probation. Is there anything else?
Nothing from the state, Your Honor.
Ms. Abrams, is there anything else?
No, sir.
Anything else you need from the court to be successful?
You don't know everything is what.
You're welcome. Anything else?
Can I just clarify? He's on deferred adjudication, correct?
Yes. All right, thank you.
Judge, thank you for all your consideration.
You're welcome.
Appreciate
You're
it.
welcome.
In the end, Christian avoids prison, barely. The judge gives him one last chance with stricter probation and treatment. This ruling proves that second chances come with strings attached. One mistake almost cost him everything. Court was justice served, or was he let off easy? Comment your thoughts below, and if you enjoy real courtroom breakdowns, don't forget to like, share, and subscribe for more shocking legal moments.